thought the keynote on strategy was very interesting. Thinking about deals at a high level, thinking about the right targets is important part of the consideration in structuring and executing transactions. At the same time, the rubber hits the road when you're actually writing agreements and putting a deal together. So this panel will be a really interesting contrast because we're going to start to shift the discussion to very individual M&A term sheets, deals, and what's market. And we're quite lucky to have both an impressive panel and really an anchor to that in some research that was done by our panel moderators firm, SRS Acquiom. They are one of the most respected brokers and clearinghouses for mergers and acquisitions, representing shareholders, providing escrow services, bringing some new technology to an area of deal processing that's quite unique. It also gives them a very, very interesting perspective into the actual terms of deals that are getting done in market. So that's an interesting foundation that the co-founder and chief executive, Paul Koenig, is going to be able to speak from and structure today's panel. So with that, let me hand it over to Paul. He's going to introduce our other panelists and enjoy the conversation on M&A deal terms.
Thank you. So my company, for anyone in the room that hasn't worked with us and isn't familiar with us, SRS Acquiom, we serve as a shareholder representative after closing. So what that means is if indemnification claims come in and the buyer says something was misrepresented or there's a working capital adjustment or whatever there might be, they will send the claim to us, and then we are involved in trying to resolve that dispute. The same applies with earnouts and whatever else happens after closing. And so that's the perspective that we bring. The other two panelists are practicing attorneys. I used to be a practicing attorney here in Chicago, and they, I think, will have some good thoughts and comments on what do they see at the negotiation stage. So, Raam and Kevin, you want to quickly introduce yourself?
My name is Raam. Jani, I'm a partner with McDermott Will Emery. We are an international law firm with over 1,100 attorneys around the world, and I'm based in Chicago. I do mostly private equity M&A work, and so I think this topic is apropos for my practice.
My name is Kevin Cunningham. I'm a partner at Mayer Brown, based here in Chicago. I have a practice that focuses on mergers and acquisitions, joint ventures, other strategic corporate transactions.
So good. So jumping right into it then, I'm going to talk about what are some of the things that we see after closing that don't work out quite as well as maybe the people thought they would at the time that they negotiated the deal. And the first here is working capital issues, and that's the purchase price adjustment. There are a number of ways that this tries to get formulated, but it's the notion of, I'm willing to pay $100 million for your business under the assumption that you have some amount of net working capital. If you don't, I'm going to have to put more into the business, and so that is going to cost me more. So after closing, 60 or 90 days later, once all the accounts have cleared, we will see if there's an adjustment up or down. A lot of times, the parties, I don't think, fully understand the nuances of how this works. And there are a number of surprises that come up later, some of which are outlined here. And so, the possible double counting, and this one sounds obvious, but you would be surprised how many times we see this issue, where the first section of the document will say, we're willing to pay X dollars for your business, plus accounts receivable, less transaction costs, plus or minus 4 or 5 other things. It then gets to the working capital section, and it says working capital adjustment will be some version of current assets minus current liabilities. But what a lot of times they fail to do is to say, except for the things that we've already counted. So we've already backed out the transaction expenses. We're not going to take them out again. And if you don't have that reconciliation, then what happens a lot of times is the buyer will say, we're looking at the working capital section, and the working capital section says current assets minus current liabilities. It says nothing about except for the ones that have already been counted. So make sure that those sections work together the way they should. Written off accounts receivable. So this is fact pattern that we see a lot of times is at the time of closing, there's a good receivable. But then for whatever reason, 60 or 90 days later, it's become distressed. The buyer says, look, we think we need to write this off. We no longer consider this a good asset. Well, that might be valid and that might be true, but one of the things you might want to think about is putting a provision in your document that says, if that happens, if the buyer is going to say, okay, there's going to be a downward price adjustment because we're going to be writing off this receivable, then assign it to us. If you're getting a price adjustment for it, then let us go try to collect it. Or if it comes in later for whatever reason, but don't let it be that one of the side gets double paid and the other side gets dinged on the price for that. And a similar, sort of go in the other direction, taxes. Oftentimes the buyer will say, well, we're taking a conservative view of this. Our accountants have told us there might be some tax that is due in the state of Utah or whatever it is. And so we're going to go ahead and pay that. And we're going to push the price down as a result. We might agree to that, but the same is similar to the working or the accounts receivable. We might say, okay, but we think this is a really conservative way of going about this. We're not so sure this tax is due. So if we end up getting a refund and you've pushed our price down, we should be assigned that refund, or we should be allowed to go out and try to pursue that refund. The closing on the odd dates. That can create the issues with accruals, and some of them are simple. If you close in the middle of the month and you know the monthly rent is $10,000, and you can pretty easily attribute, well, how much of that is pre-closing or post-closing. But the one that can be big and really tricky on this is bonuses. Because a lot of times bonuses, they're not a certain expense. The buyer will say, well, they get paid in some years and they don't get paid in the others. And until we get to the end of the day, we don't know for sure that we are going to be paying them, so we shouldn't be accruing for them. Buyer will take exactly the opposite view, saying that's ludicrous. You have to accrue for bonuses because there's a high likelihood of them not being paid. Well, if you haven't clarified that in your deal, if it's 20% of payroll that potentially is paid out in bonuses, that can be tens of millions of dollars. That's a big shock to a working capital adjustment that might not have a clear answer. And the second bullet point there, the seller's closing balance sheet is not the buyer's opening balance sheet. Our people that work on our team that do this, the accountants will say, hey, buyer, you can do whatever you want with your accounting principles the day for your opening balance sheet. That's not what this exercise is. This exercise is to prepare the seller's closing balance sheet in accordance with the policies and principle that seller always used in the past. So if you want to be more conservative about how you treat certain things, that's fine, but that's not what this exercise is. And then the final one down there, this is one that deferred tax assets and liabilities. A lot of you I know this, that companies keep multiple sets of books. For GAAP purposes, you might want to post as high an income number as possible. For tax purposes, you want to get that as low as possible. And there's a reconciliation between the two that is really an accounting fiction and doesn't have much of an impact on the value of the deal. But we've had transactions where there is $1 million price adjustment because of these deferred tax assets and liabilities. And we try to make the argument, come on, that doesn't really impact cash or cash equivalents or the value of what you bought. But if you look at a lot of working capital definitions, that's in there. So these are some examples of many. Point of this is make sure that when you're working with your attorneys, and a lot of attorneys aren't accountants, and this is not something that a lot of times the deal parties fully understand, that you really work through, is this adjustment working the way we intend? Information rights, the other side of Great Hill. So Great Hill was a case that came out a little while ago, and there have been two issues on Great Hill. One has been aiding and abetting liability of a private equity fund. But the one that came out first was an issue where the communications between the target company and its stockholders, they got into a dispute later, and the target company not its stockholders, excuse me, the target company and its attorneys. The buyer made a claim and said it was entitled to review those communications. The target company tried to argue, no, that was our law firm, that's privileged communications. And the buyer said, no, actually the target company was the client. We acquired the target company. When we acquired the company, we acquired the right to the communications as well. The court agreed with that, which caused a lot of consternation because that's not the outcome that many people thought it would be. But the issue, and that's an important issue, the issue that we see from a practical perspective come up more often is not how do we prevent the buyer from accessing the communications with the attorneys pre-closing, but how do we ensure that we as the shareholder representative make sure we have the ability to get rights to information that we need. So if the buyer asserts a claim, they might say, hey, we have a patent issue, here it is. Our response might be, well, okay, that's fine, but we would like to see the supporting documentation. We'd like to talk to the management team. Sometimes the buyer will say, no problem, here it is, let's try to get this resolved. Other times they'll say, absolutely not, that's confidential, they're our employees, don't you dare try to reach out to them. So unless you put into your document something that says, If you assert a claim, the shareholder representative will have certain rights to access to information related to that claim. You can find yourself in a difficult position where you say, well, what are we supposed to do about that? We could fight this, but we're kind of fighting it in a blind way. And if we proceed and it goes to litigation, we don't really know what we're working with. That puts us in a tough position of we don't necessarily want to settle because we don't know the facts, but we're also not that excited about going to litigation without knowing the facts. So our claim study, we are blessed to be in the business where we get into a whole lot of these disputes just by the nature of what we do. And we put out studies, one of which is a deal term study that says, well, what do the documents say on their face? But another is a study that says, well, how often are there claims? And where are their claims? Where do they come from? And how long do they take to get resolved? And what are the dollars that are involved? So this slide, this is a highlight of some of the takeaways from our claim study. And the first one, 2/3 of the deals that we've had that have had an expired escrow have had at least some issue arise after closing. Now, those aren't all indemnification claims. That's indemnification claims, working capital adjustments, or a dispute over earnouts. But these, we don't count low-level administrative type of issues. These are real substantive issues that required attention after closing. So there is absolutely, what I always tell people is it's more likely than not that you're going to have the work to do before this deal is finally done. But our data also does show that at the end of the day, the majority of the escrow on most deals does eventually go out to the selling stockholders. 18% of, almost a fifth of the deals had a claim come in the last week of the escrow period. Not terribly surprising. I think a lot of buyers will put a reminder in their calendar, and when the escrow is about to expire, they look and say, do we have anything that we want to assert? But if a stockholder calls us in the middle of an escrow and says, no news, that's good, right? Our response always is, well, yeah, sort of, but let's not high five yet. Until it's over, we don't really know how this is going to pan out. And the practical consequence of that is, I understand why it happens, but the dynamic is now that you are 18 months after closing and we're trying to react to whatever it is that the buyer has said, it's harder. The people the management team has gone their separate ways. The files are in storage. And so the buyer will say, hey, there's a problem with our Oracle contract. And we'll say to the management team, what do you remember about the Oracle contract? And CFO will say, well, I've had another job now for 15 months. I sort of remember it. So I understand why it happens, but the practical implications are, they can be pretty significant. And then the other thing that does is it locks up the money until that claim is resolved. So if you don't start the conversation until the very end, you keep that money tied up until you work through the process, rather than if you had started the conversation 3 months after closing, the balance of the escrow would have gone out on time. The 12% of deals that go to litigation or arbitration, actually I missaid that, deals with a claim. It's not 12% of all deals, and that's an important distinction. But 12% of the deals that have a claim end up going into litigation or arbitration. That's pretty significant, and especially if you are an individual serving as the shareholder representative. And the story that I always tell people on that is I have a good friend who is a partner at an investment company, and he agreed to be the shareholder representative on a deal. Something went sideways on the deal at the time that he was trying to buy a house, and the bank denied his application for a mortgage. And this is a very successful, very wealthy individual. They said, we can't give you a loan. You're a party to a $150 million lawsuit against you. And he tried to explain, sort of, come on, it's not really against me. It's against me as a shareholder representative. I'm not going to lose any money. And the bank said, well, your name's on the cover. And by the time he got that worked out, another buyer took the house. So it's not just the nuisance of nobody wants to be deposed for 2 days. It's a question that they ask on health insurance applications. If you're raising another fund, it's a question that an LP might ask. So while it's not a huge percentage, it does have real consequences. And then the last point is just, when the claims come, they can be significant. Earnouts, the point I want to make on that is earnouts absolutely are, and what I mean by earnouts are, we'll pay some amount for your company now, we'll pay more later if something happens, if the drug is approved, if you hit your revenue numbers, whatever the test is. They will always be probably the highest risk area of M&A, but they really do get paid. It's not the stuff of unicorns. And I've heard some people say, well, don't do a deal because of the earnout and just treat that like a lottery ticket. Yeah, it's high risk, but they do have real economic impact on a lot of transactions, and they're not fiction. So the claim types and the subject matter. A few things that are interesting on this. First of all, you see that breach of rep and warranty are the most prevalent. Purchase price adjustments come after that. But then in third place there, that fees and costs. And we get a lot of these. And a few of those are the final legal bill. That doesn't tend to be really interesting. What most of those are the buyer has some third party assert something against them, whether it's a patent troll or a former employee or whoever it might be. And that third party, what they're asserting might be nonsense. But the buyer has to incur real expense to make it go away. Are they entitled to recovery of those fees and costs? And from the buyer's perspective, they'll say, well, I'm out real money. You know, I had to spend, I'm not making this up, I had to spend money to make this patent troll go away. But from the seller's perspective, they look at that and say, but we didn't misrepresent anything. You know, I'm sorry you're having to deal with this crazy person, but that's not our fault. Well, the nuances in the documents around that point can be really important. You know, if it says that if a third party alleges something that, if true, would be a breach of a rep, we're entitled to our fees and expenses, then we don't have much of an argument against that. But if it says that what the third party alleges needs to be an actual breach, then you come to a completely different outcome. And that 12% tells you this is not a hypothetical, you know, it could happen occasionally, it happens a lot. And then on the other side, you know, one of the takeaways from that is there's not a huge concentration in any one area. So it's not like all the action is around intellectual property or tax or environmental. Claims come from all over the place. So you have to really focus on what all the risks are in every representation that you make. You see tax is the biggest. What we see most on tax is it's not the obvious taxes that you would think of. It's not federal income taxes. They tend to be the taxes that people are not as focused on. City of San Jose personal property taxes. Sales and use taxes can be a big one, especially if you're dealing with a technology company. Because a lot of technology companies will be software bundled with services, sold in lots of jurisdictions where there are lots of reasons the tax might not be due. But if you sold this software to 800,000 customers, the drill of going through, well, what of that is subject to sales and use taxes now all of a sudden is a bear. A couple more points here. Return of stock certificates, in the context of mergers. And when I was growing up as an attorney, I was always told you have to get the original stock certificates back. If you don't, you need to get an affidavit of loss and potentially a bond against that. That's actually not the way the UCC works, which surprises a lot of people when I tell them this. But what this UCC Section 8207 says is that an issuer, which includes the parties to a merger transaction, is fully protected in making, whether it's a dividend or a payment in connection with a merger, paying its registered holders, even if someone else is the actual holder of the shares at the time. So if someone sold their shares the day before to the merger to their neighbor and didn't tell anyone, and then that person collected the merger consideration when the neighbor is the actual holder, the neighbor only has a claim against the person that sold it to them, not against the company, because they did not notify the company that they're the registered holder. So all this stuff where you have to go to the vault and find the original stock certificate and hopefully you still have it and mail it all back in, that's actually not the way. It's true if it's a stock purchase agreement. It's not true if it's a merger. And so if you're getting pushback from a bank or anyone saying you have to post a bond against that, look at this Section 8207. And then the final thing that I'll touch on before turning it over, this hasn't really surfaced yet, but it's starting to come. So a lot of you probably saw in the press last week a story about JP Morgan is starting to charge its customers for their deposits. Well, the same thing is going to likely be coming with escrows, because escrows, by their terms, can move anytime for any reason. And the banks are now, because of these new liquidity coverage ratios that are requiring them to increase the reserves against those deposits, are going to start looking at these and saying, are these attractive deposits or not? So I think that you can expect that you will see with a lot of the banks that have historically done this business, they're going to start saying, if we're going to take an escrow, we're going to pay nothing for it, and we might start charging heavy fees to do it. So then you say, okay, well, if they don't want the deposits on their balance sheet, what are they going to do? And the first instinct will be to say, okay, we'll push it off to money market funds. That's off our balance sheet. We don't have to reserve against those. The problem is you used to always be able to carry money market funds at a stable dollar NAV. So if you put $1 in, you got $1 back plus your interest. They didn't look to the market value of the underlying securities. The rules allowed for that. Well, starting mid next year, so it's relevant to any escrows you'll be depositing today, those go to a floating NAV. So now all of a sudden, if you put $1 in, you're not necessarily guaranteed of getting $1 back. And so then the question will be in merger context, well, if it's less than $1, whose liability is that? Who's taking that risk of the deposit? Is it the buyer or the seller? And you better start figuring that out, negotiating it now, because it's not as much of a slam dunk as it used to be. So then you'd say, okay, well, what about the third option, treasuries? Treasuries work. They're not going to be subject to the floating NAV, but what you're going to see is a big imbalance between supply and demand, because this isn't just relevant to escrows that you establish with M&A transactions. It's going to be all sorts of deposits. So when 2008 hit, there was such a flood into treasury funds that some of them had to close additional deposits. So the point of this is, what were the obvious choices of what do you do with an escrow in the past? The landscape may be changing on that in the very near future. So with that, I will turn it over to Raam.
All right. Thanks, Paul. That was I think, a really good and helpful introduction of real issues that we see every day in the merger agreements and purchase and sale agreements that we're doing. And I think a lot of that stuff is very real world and very practical. So for the make sure you're talking to your lawyers about it, and make sure that that we understand what it is that you're trying to accomplish with the different things that you have, whether it's a working capital adjustment or other sorts of purchase price adjustments, because we know how to draft those contracts. We're not going to put in the things that get double counted and that sort of thing. We won't make mistakes like that. But if there are actual deal issues that you need to have accounted for that we would have no reason to know, then you need to tell us those. And so but I thought that was a really good talk. So my couple slides here are really more specific on a couple of recent developments in Delaware, and I think these are things to just think about for your company, whether it's a private equity-backed company or it's a public company. Some of these things can be applicable, and this is sort of it's just changing as we speak. So it's something to keep your mind on, because a lot of companies don't look at their bylaws very often. They have bylaws. They were adopted in 1950. Nobody pulls them out until there's some issue, and then when you look at them, nobody really knows what's in there. So the first case that I want to talk about is the City of Providence versus First Citizens Bank Shares. And this is a case where the City of Providence was a stockholder in First Citizens, and First Citizens was acquired First Bank Corp in North Carolina. And on the day that it announced that it was going to merge with this corporation in North Carolina, it adopted a bylaw adding exclusive forum in North Carolina. So it was saying that you have to bring a suit in North Carolina. And of course, that wasn't particularly convenient for the City of Providence. And it was a Delaware corporation, so Providence was sort of hoping that it could litigate in Delaware, which would be something that would be mutually convenient or mutually inconvenient for the companies. And the Delaware court, so the stockholders challenged that and said, you can't do that. You can't just make it only that we can bring suit in North Carolina, because that's obviously home field advantage for you, because it's a North Carolina corporation that you bought. And the court actually said no. The court said a Delaware corporation may adopt a bylaw that designates an exclusive forum. And they had previously, in a case the prior year, Chevron case, they had said that Delaware could adopt Delaware as the exclusive forum, and that sort of made sense because it's a Delaware corporation, and every stockholder should, sort of assume that they may have to go to court in Delaware. But this ruling actually said you could make any state the exclusive forum. So if you have an Illinois corporation, or not an Illinois corporation, but if you're headquartered here in Illinois, even with a Delaware corporation, you could adopt a bylaw that says, stockholders have to bring suit here in Illinois, and that might be something that would be beneficial, to a corporation that's headquartered here. So this is one of those cases that could have some real practical impacts for the people in the room. The next one is a little less certain as far as what the law says. So it's pretty clear what the Delaware law and what the Delaware court said about the forum selection clause. But the other clause that companies were trying to put into their bylaws is a fee-shifting clause. And so this is in litigation. The American rule, generally, the American style is that each party pays its own legal fees in a litigation. But, of course, in a contract, and many contracts have a provision that says loser pays or splits the legal fees in some other way. And so the Delaware court says, bylaws are essentially a contract among the stockholders, and so you can contract in your bylaws to have this fee shifting provision that says the loser in a litigation would pay, and that type of provision will deter stockholder suits, because stockholders many times in the plaintiff's bar wants to be able to bring suits. That's kind of what they do. So they want to make sure the stockholder can bring a suit, even if it's not sort of a slam dunk winner. They want to be able to bring that suit, and a lot of times it'll get settled for nuisance value or something. But the plaintiff's attorneys are then going to make some money off of that, and so. There was a case that was a non-stock corporation. So this was not a public Delaware corporation. This is a non-stock corporation, the ATP Tour, the professional tennis tour. They had a case that said that you could, in fact, have this fee shifting provision in the bylaws, and the Delaware bar. And so that is the law for non-stock corporations, and the Delaware bar, which is many of whom are part of the plaintiff's bar, they came out and tried to get a law passed in Delaware, a statutory law passed in Delaware in the legislature there that would say that in fact is not permitted. That law did not it hasn't gotten out of committee yet, so it's still under review. So currently the case law says that a fee shifting provision is permissible in your bylaws for a non-stock corporation. So this is another one where when we advise clients, this is one where we would not say it's a slam dunk, this is an enforceable provision, but it is a provision that you could consider including with your bylaws if you wanted to deter stockholder litigation. And I'll turn it over to Kevin.
Thanks a lot, Raam. So I wanted to turn to a couple Delaware cases today that are, I think, having important implications for both deal structure and deal terms. The first of these is Cigna biotics, which I think will have a major impact on how private mergers are being structured. And before jumping into the case, I thought it would be helpful to take a moment and revisit exactly why parties in a private deal context would choose to do a merger structure over, say, a stock purchase. And the short answer is that mergers are an excellent tool to solve collective action problems. So if you have a stockholder base in your target company that is diffuse and relatively numerous, a merger structure is going to be able to accomplish the deal, move the deal forward to close so that the buyer can obtain 100% of the equity without having to get 100% agreement from each and every stockholder. So that's the exact same reason why merger structures are ubiquitous in public company deals. Obviously, it's impossible to get agreement of every single public stockholder. But in a private company context, merger structures have disadvantage that I think is more pronounced in a private company deal than in a public company, for the reason that in private company deals, a lot of times buyers are seeking more protection on a post-closing basis, in particular indemnities. So breaches of reps and warranties, et cetera, they're going to seek indemnity recourse after closing, whereas in a public company deal, that's very rare. And so the disadvantage is that in a merger, because you don't have 100% agreement, you don't need 100% agreement from your stockholders, you're oftentimes not going to get 100% agreement. And so there's no real way, good legal hook, to bind non-party stockholders post-closing. And buyers and their counsel have come up with a variety of creative solutions to bridge or address this risk. A common one is these letters of transmittal, which effectively are a cover document, a fairly simple instrument whereby a selling stockholder is going to deliver its shares and receive payment in return. And that was exactly the mechanic that was at issue in Cigna biotics. In the case, Optum Services agreed to acquire the target audits. The merger agreement had some fairly customary provisions for a private company merger. It had indemnities from the stockholders to the buyer. In this case, it was up to 100% of the merger consideration. What was fairly unique in the case is that there was no escrow. So effectively, the recourse of the buyer was a $1 clawback from the stockholders. So it would seek recourse directly from the stockholders after closing, which is fairly unique. Another feature that I think is a common feature is that the indemnity covered reps and warranties. And the reps and warranties survived, most of them, for a definite period, 18 to 36 months. It's fairly market. but some fundamental warranties survived indefinitely. And the letter of transmittal in the case, it used this construct whereby there included a general release of all claims, as well as an indemnification obligation of the stockholder, effectively requiring the stockholder, as a condition to receiving the merger consideration, to sign on to the indemnity obligations that were in the merger agreement. Again, a fairly common mechanic, pre-Cigna at least. And so along comes Cigna, who was a preferred stockholder of Audix, did not vote for the merger, did not sign a support agreement or other ancillary agreement, and indeed refused to sign the letter of transmittal. They were denied their merger consideration, didn't get paid, and sued. So this case, and I've given away the punchline here, but effectively the court held both the release obligation and the indemnity obligation unenforceable. Specifically, it was a reading of the Delaware statute, section 251, which has the nuts and bolts of exactly the legal requirements and the mandatory conditions to have a good merger under Delaware law. And effectively, the court read 251 to say, as soon as your merger is closed, your stock is automatically converted into the right to receive merger consideration. And so a release in a letter of transmittal or other document that's not reflected in the merger agreement, effectively, there's no value delivered from the releasee to the tendering stockholder. And so basic tenet of contract law is that you need consideration for any obligations that are agreed to under the contract. And so that was held unenforceable. And more interesting, to lawyers anyway, was the rationale of why the indemnification obligation was held enforceable. Effectively, the court took a pretty nuanced reading of Section 251 and held that, at least in this case, and it remains to be seen how broad this application is, but at least in this case, the stockholders were effectively unable to ascertain with any definitiveness the value of the merger consideration that's being paid to them because, again, as you'll recall, there was a $1 clawback of up to 100% of the merger consideration, and effectively, for at least some representations, an unlimited term of the reps and warranties. So you never precisely knew how much you were getting, and the court found that to be invalid and actually stated that it was a violation of Section 251, which is a little scary for a buyer who thinks it has closed a good merger, and all of a sudden a letter of transmittal is violating the underlying statute. So basically, both obligations and this whole mechanic of using letters of transmittal were held to be effectively unenforceable, and that's an issue. Again, going back to the original reason to do merger structures, you're going to have agreement only of a portion of your stockholder base, and so the non-party stockholders, it remains to be seen how and exactly to what extent you're able to obtain obligations from them on a post-closing basis. So these are a few ideas on how a buyer might mitigate that risk. You could increase your escrow coverage. Again, sellers might have other ideas about that, but it is a fairly straightforward way to address the risk. The court was careful to carve out escrow coverage. And you could obtain support agreements from individual large stockholders. Oftentimes that's the case in private company negotiations. You'll get large stockholders on board. And consider making the merger consideration ascertainable. Instead of having 100% recourse, maybe you're going to settle at 95 just to fit within the specific bounds of this case. So I'm told I'm fast running out of time, and I'm sensitive to everyone's schedule. So I will just breeze through this last one. I think it's a fairly narrow holding. It's very interesting for purposes of very common contractual provisions. Interim operating covenants are how the sellers agree to manage the company between buying and selling. And I guess just to say a couple quick words about this, it's very common for a seller to agree to operate in the ordinary course, and that's what we see in the bolded language here. This case was interesting because it fell apart rather spectacularly. It was in the news, but effectively the seller's JV partner seized its facility in China, which is a major business reason for doing the deal in the first place. Seller had to take extraordinary steps to address that issue, and the court ultimately found that those extraordinary steps resulted in a breach of its obligations to act in the ordinary course. And I think a lot of lawyers, and certainly Cooper Tire, would have read ordinary course to mean what you can control. But the court held otherwise, and that same issue popped up in the MAE clause, which is a fairly significant provision to allocate risk of unforeseen or unknown events between signing and closing. So I'll go ahead and wrap it up there, just so we stay on time and have time for questions for any of the panelists. Okay.
Is this only relevant to Delaware law or Delaware law?
The
I mean, if your company's organized under Illinois law, for example.
No, absolutely. You run into the same issue. In most states follow a similar statutory construct for Delaware, and also Delaware is obviously far and away the leading jurisdiction, both in terms of the number of companies incorporated there, as well as the jurisprudence of Delaware law is followed in many states. So the specific holding would not just apply, or would just apply to Delaware, but I think you're going to start seeing the ripple effect through other jurisdictions as well.
Thank you very much for your research.